All right, so our next panel is yet another segment of takings, part of John's imagination on takings. If we could, we're going to get going here. This panel is a two-member panel. It's takings and insurance. I was talking to Chris last night about this, and Samantha, I understood, sort of stepped in when somebody else was unable to participate in this. First speaker is Samantha Medlock. She's at the White House. She's at the Council on Environmental Quality, or CEQ. She works as the Deputy Director for Climate there. And Chris Serkin is a professor of law at Vanderbilt Law School. He works on land use and property issues. I wanted to mention one other thing, just because I'm so divorced from news. I got a text from my son telling me that apparently Speaker Boehner has resigned, as he's resigning the end of October, and not just as Speaker, but from Congress. So if anybody knows what that's all about, I'd be happy to learn.
Thank you very much. Well, while I won't speculate on any of the backstory behind the decision of the Speaker to resign, there's scuttlebutt that there was apparently something that His High Holiness may have said. We'll leave it at that. But I want to thank you all for gathering here, and John, thank you for arranging this and for inviting me to be a part of it. I'm Sam Medlock with White House Council on Environmental Quality. I'm also a VLS alum and a proud floodplain manager for the better part of 20 years of my career. My focus right now, though, will be on the federal policy initiatives in this space, specifically around flood risk and climate, but also looking at the role of insurance and the ways that insurers and the industry can be helping to better identify risk and articulate that and ultimately buy it down. One of the themes that you may hear me return to a few times is actually working to keep things out of court and reduce the risks of litigation. So I'll probably allude to that a few times in what I discuss. By way of background, I think that folks are generally familiar with the broad flood risk policy regime in the United States. It rests primarily with state and local government in a constitutional democracy when it comes to land use and building codes and permitting. But there are key federal roles related to, for one thing, mapping and the National Flood Insurance Program, and then also in large-scale infrastructure in the form of what used to be called flood control projects. Now we call them flood risk management. For a while there, we were calling them flood damage reduction. I call them flood control, even though it's less about controlling the flood than it is about protecting high-value assets behind these things. So this is where things like dams and levees, flood walls, and other traditionally conceived of as hard armoring engineered structures, but increasingly we see flood control or flood risk management also around greener approaches or hybrid approaches, things like setback levees or floodplain restoration or other measures. Additionally, of course, there's a strong federal role in producing suites of incentives and disincentives that may be driving state, local, and tribal behavior or choices even of private actors. So one that I'll return to a bit later is the role, for example, of federal disaster relief. So put a pin in that for now. But we recognize ultimately when it comes to floods and flood risk, the first and last line of defense is state and local governments and tribes. We recognize that, and that's why the President stood up the State, Local, Tribal Leaders Task Force on Climate Preparedness to advise the White House and the administration on what these governors, mayors, county leaders, and tribal leaders most need from the federal government in managing climate risk. And the recommendations came through loud and clear. And they focus in really, I think, three broad categories of action. Data and information. Decision makers at every level of government need robust data and information. On the flood front, it's a need to understand what do future conditions look like? What does future risk look like in 5 years, 50 years, and 100 years? So that we can be informing the design of a community, but also the design of an asset or a piece of infrastructure or an investment. But we also heard that amid all of that data and information, because there's a lot of it, they also need technical assistance and help parsing through all this data, even just in the sea level rise space. There are a lot of projections that are out there. There are a lot of choices, and the farther out you project, the greater the ranges of uncertainty become. So if you're a governor or a planning commissioner or a local emergency manager or a fire chief, and you're trying to make planning decisions that involve land use or public safety, parsing through all that data is something that communities need. But they also need help parsing through the full range of options that are available to them. In a pre-disaster context, they can be regulating using just the flood insurance rate maps or just the information or data that are coming through in science, or they can be building in margins of safety. In the floodplain management world, we might call that freeboard, or an additional vertical elevation that would be required for construction so that things stay higher and drier, or setbacks, backing off of floodplains, or looking at steep slopes that are prone to erosion, looking at the wildland-urban interface where wildfire is posing a greater risk, looking at issues around drought. Those decisions rely on data and information, and parsing through all of that is important, but also parsing through the full range of governance options. Even in the post-disaster context, when mutual aid agreements come into play and one community is sharing resources with another in that time of need, issues around liability around those decisions come into play. Also, decisions in a post-disaster context, especially in the immediate aftermath of a disaster, of whether or not to do a moratorium or put a halt on new development or permit processes while the community catches its breath. These are all things where communities need technical assistance, and that came through loud and clear in the recommendations to the President. And then, of course, that mix of incentives and disincentives. This is where federal policy or practice, the design of programs, and ultimately federal money can serve to either incentivize rigorous and robust leadership on the part of state and local governments or not. So let's talk for a moment about the role of disaster relief. Folks that remember the debates after Hurricane Sandy took 90 days, $60.4 billion of federal disaster relief that was distributed primarily to the Sandy-affected region, but to other areas that suffered declared disasters after 2011. It's a lot of money. So what role does that money play when a community is looking at permitting decisions and they're getting pushback from developers who are saying things like takings? And what incentive does a mayor have to be courageous and to say, we in our land use decision making have decided that these areas, whether it's the wildland-urban interface or steep slopes or floodplains, are simply inappropriate for new development? When sitting across the table or coming to that public hearing is somebody offering jobs and offering tax base and talking about takings. So the idea is to help those communities that are ready to be courageous and those states that are ready to adopt strong building codes and statewide freeboard and identify areas that are risky and help give them the courage to do that and make sure that they don't roll the dice with everybody else's money. Because increasingly, we are seeing, I call it going to appropriation school, but the more data and information that we have about some of these physical and natural risks, the more we hear appropriators ask when it comes time for federal disaster relief, to what extent are these self-inflicted wounds? And why is it the responsibility of a taxpayer in Nebraska to bail out a coastal community that permitted new development in harm's way and knew it? So these are questions that are coming up more and more frequently and are coming into that debate with regard to federal disaster relief. This came through loud and clear from state and local tribal leaders, and what they are looking for is that mix of incentives and disincentives. So I want to talk a little bit about an approach that is no secret, but it is borrowing from the insurance industry and looking at the concept of a disaster deductible. If you look at FEMA's strategic plan for up to 2018, you see this alluded to. But let's think that through for a moment, so that on public assistance, this is the really big federal money that comes through FEMA programs after a disaster that can go toward things like infrastructure or rebuilding City Hall, roads, or other things. Bless you. If we actually attached a concept from the insurance industry in the form of a deductible, whatever form that takes, but let's say it's 10%, just like you and I have on our homeowner's insurance or our auto insurance or our health insurance. Many of us have a deductible. We have to meet that before the benefit kicks in and the payout kicks in. So what does that look like, though, to be an incentive? How about if you are able to buy down that deductible by adopting things like freeboard, that additional vertical margin of safety, or backing off of that floodplain a bit, adopting a statewide building code, avoiding the wildland-urban interface, adopting standards with your neighboring communities, like no increase in erosive velocities, no loss of valley storage, other measures that many communities are already putting into law and have stood up under challenge. And by doing that, we are buying down the disaster deductible so that communities that leaned in and showed that courage and recognized and regulated areas that are inappropriate for new development go to the front of the line. And those that chose not to do that are going to face the deductible. So it's a concept, it's an idea, and it's not a new one. It's an idea that we can borrow from insurers. In addition to the President's State, Local, Tribal Leaders Task Force, he called for a partnership with the insurance industry. So I'm going to talk about that a little bit and the things that we're learning from working with the leading property and casualty insurers that are operating here in the continental United States. Let's be honest, at the end of the day, this is about insurers being able to charge the premiums and produce the products that they feel like they ought to be able to charge and produce. This is a very risk-averse industry. This is not a uniformly altruistic industry. This is a profit-driven industry, and rightfully so. They have shareholders that they're beholden to. But they are keenly interested in natural hazards, especially flood. They are keenly interested in the impacts of climate change and being able to anticipate those impacts over time and the way that it may affect their industry or their portfolio or their future profit and viability going forward. So we've been talking with them, and we found very strong common ground across the administration and with the insurance industry on three big areas: building codes, and building codes. They work, they buy down risk, they communicate risk, and when it comes to new construction, building codes can help make it more resilient. It can also help the occupants of those structures better afford their insurance because it reduces risk, it makes that insurance more affordable. But even with regard to existing assets, rather than using that $60.4 billion to rebuild the Sandy-affected region exactly as it was before, finding ways to rebuild it to be stronger and to be more resilient. So for example, we saw the Sandy Task Force promulgate a standard that when you're spending that $60.4 billion to rebuild something that has been substantially damaged and it's at flood risk, you're going to rebuild it higher. It was the first time in our nation's history that we saw a federal freeboard. State and local governments are doing it across the country. They have been for decades. But for the first time, the federal government acknowledged that the so-called 100-year is not good enough, not when you're spending federal money. So most recently, the President issued in January Executive Order 13690. 13690. Folks that are familiar with it. Oh, great. These are the guys that have been nodding the whole time I've been talking. Okay. This is going to be a big deal, folks. We are going to change the way we spend every single federal dollar in and around floodplains. For the first time since 1977, we have a new approach. And so the president directed departments and agencies across the federal family, not just FEMA, not just HUD. This is across the federal family. This is VA with hospitals, and this is DOT with bridges. This is Army Corps that already does an incredible job, by the way. This is SBA. This is across the this is EPA wastewater treatment plants across the federal family. If you're going to be building something in a floodplain and it's a federally funded project, you're going to use higher standards. And we've produced a flexible framework for agencies to choose from and how they're going to do that. Does it mean that wastewater treatment plants are going to be located 12 feet up in the air? No. There's a practicability element to this. But it does mean that those wastewater treatment plants are going to be more resilient to a given standard than just the 100-year. They need to be able to withstand a flood and continue to operate and continue to serve the public relying on it. So stay tuned. Where we are with that right now is we are producing interagency guidelines. As those go public, each department and agency will then go through the process of updating their rules and procedures to implement EO 13690 that actually amended a 1977 executive order. So again, for the first time in 38 years, we are seeing a significant policy advancement in federal practice. With that, I'm actually going to wrap up, but with a cautionary tale on the subject of litigation. I'm not sure, because I just arrived, whether or not Columbia Venture was discussed here, but in short, when a local government does want to lean in and they get pushback and challenges about takings and find themselves tied up in litigation for 10 years and millions of dollars of expense and a lot of uncertainty for that community, it's very costly and it's not as helpful. So I would say the more that we can address these issues in statute, in standards, in transparent policy and law, the more efficient it will be, the more everyone will have certainty in the process, and the less these things get wrapped up in court. I'm going to stop there. Okay.
That was an unbelievable prescient segue into my talk, actually. But first, I want to thank John for having me here. This conference is so terrific. I always learn from it, although I have to say he's thrown me under the bus a little bit, having to talk to you all about municipal insurance just before lunch. So my job is to convince you that, in fact, this is an interesting topic that people haven't paid enough attention to when thinking about the incentives of local governments in particular in regulating and in dealing with takings risk. So I should say I'm primarily a property theorist. I write big abstract pieces about lots of esoteric topics. This is a real divergence, a departure for me in this work. But it's convinced me that there is a lot of action here, and this is a topic we should be paying more attention to. So municipalities, comes as no surprise, they face risk on lots of fronts. They get sued all the time, workers' compensation claims, car accidents, torts, right? 1983 claims for police misconduct, all sorts of things, employment discrimination claims, and regulatory takings claims. They get sued a lot. As you might expect, many municipalities, smaller municipalities, for reasons I'll talk about in a minute, typically have insurance for these kinds of claims. They insure against these kinds of claims in just the ways that you would expect. But what you might not expect is that they don't have insurance for regulatory takings litigation. And in fact, as far as I can tell, given my research to date, insurance is not available to municipalities for regulatory takings claims. This is just not a product that insurance companies offer. So I want to spend my time today thinking a little bit, talking a little bit about why that is, why I think those reasons are actually insufficient, and talking a little bit about what the consequences of this hole in municipal insurance might be, specifically under regulation. So some preliminary observations, though, I think are in order, and there'll be some payoff to these towards the end. I think it's worth asking, why do local governments have insurance at all? That is, the strange thing may not be the absence of insurance for regulatory takings claims. The strange thing may be that there's any municipal insurance in the first place. Because municipalities, of course, can deal with risk by raising taxes, by raising money through other mechanisms. Right? But that, of course, I think this will seem intuitive to most people, right, misses the point. Of course, especially smaller local governments are risk-averse. Taxpayers are going to end up funding those tax increases. Municipalities can maybe spread those tax increases over time by floating bonds, by issuing debt. You can think of that as a kind of ex post insurance mechanism, but that's also not fully adequate because bond ratings will depend on liabilities, will depend on risk management practices, so they can't just wait until the liabilities come due to raise money. And of course, there's a huge political dimension to all of this, right? Individual local officials may take a political hit if there's an adverse judgment against the municipality that results in increases in taxes. The bottom line is that at least smaller local governments clearly behave in ways that suggest that they are risk averse. There was a municipal insurance crisis in the 1980s when insurance companies left the market. And what did smaller municipalities do? They closed their swimming pools. They closed their playgrounds. They shut down those things that generated legal risk. And you've got to imagine that that is a politically toxic decision to make, right? We're closing our playgrounds in the middle of summer. Right? And it suggests, though, just how averse to risk they were. And indeed, the amount of money local governments spend on risk management practices, on buying insurance, suggests that they are, in fact, quite averse to risk. Now, this is, though, an aversion that varies depending on the size of the government. So if you look, cities, larger cities, almost entirely self-insure, right? They keep the risk on their own books. They can incorporate that into their normal budgeting process. They can take advantage of the law of large numbers. They have a sense of what their liability will be. They don't go out and buy insurance. But smaller municipalities really do. They buy a lot of insurance through private insurance companies and by participating in municipal risk pools that spread insurance, depending on the state. So what does that insurance typically look like? Well, municipalities often have a general liability policy. They have specialized policies for things like police misconduct. But then they also have an errors and omissions policy, an E&O policy. And this is very analogous to a directors and officers insurance in corporate space. And this provides coverage for, well, errors and omissions and policy decisions by the government. Discriminatory hiring policies that may be in place, if the litigation results, those will trigger the E&O policy. Land use litigation typically triggers the E&O policy. But every E&O policy I've been able to find, and I've talked to a lot of insurance underwriters also about this, every insurance policy I have found includes the following exclusion, or some very close variation thereof. It excludes coverage, and here's the quote, for all liability arising out of or in any way connected with any operation of the principle of eminent domain, condemnation, or inverse condemnation by whatever name called. Okay? So why, right? I want to offer some suggestions, but I also want to critique them and suggest that they may not, in fact, hold up. So when I talk to insurance underwriters and I talk to risk managers and municipalities and say, what's going on here, right? The first answer that I get is, well, it's obvious. This is not an insurable risk. There's nothing fortuitous about this. If the government doesn't want to pay compensation for condemnation or eminent domain, don't take the property. And if the government doesn't want to pay compensation for inverse condemnation, don't regulate. Right? But that's just not right, it seems to me. Right? There is so much legal uncertainty built into the Penn Central test, built into our takings analysis, that there is genuine risk here, unlike in eminent domain. I think it's a mistake to lump condemnation and inverse condemnation in this same exclusion. They're fundamentally different. And here, right, regulations do come with genuine risk of the kind that should be insurable. It's also not the case, right, that a government can simply choose not to regulate to avoid liability. Right? There are times where failing to change the zoning ordinance or not acting in a responsive way may at least get the government sued. Even if it wins, right, there are going to be litigation costs involved. This is not a risk that they can simply choose to avoid. So even if that's right, there's a related objection, though, which is, okay, maybe it's an insurable risk. There's still an enormous moral hazard problem. Right? We don't want to provide this kind of insurance because, in fact, we think that municipal actors should internalize the costs of their decisions. We don't want them to ignore these risks. We're worried about over-regulation, and indeed, this becomes uninsurable because it will induce over-regulation, exposing the insurance companies to greater loss. But I don't find that completely compelling either. That's important. There's clearly something there. But insurance companies deal with moral hazard all the time in lots of really sophisticated ways, right? It may simply be large deductibles, it may be caps, it may be different ways of performance rating things. They deal with moral hazard, and they provide insurance against legal risk and liability in contexts that look to me to be indistinguishable from this. I just don't see as a principled reason why this can't be offered here. Fundamentally, though, when I talk to risk managers, when I talk to insurance companies, the overwhelming message I got was that no one understood what regulatory takings liability was. Right? I would say, gee, you have this exclusion for condemnation and inverse condemnation, and they would say, yes, right? Are those different? And I would explain to them, yes, they're different, right? They're importantly different. There's risk in one, there isn't in the other, and say, oh, no, that's an interesting point, right? So I hesitate here to say that the market is sort of failing to provide this valuable service. So let me just make one more comment about the actual market for insurance. One of the interesting observations, though, is when I would talk to insurance underwriters about this, convince them that this was something that was important, I could even get them on board saying, well, that does sound interesting. Right? And then they say, but we're not going to do anything about it. I say, why not? I said, our incentive to innovate in this space is very, very small. Because municipalities, by and large, are going to buy either the cheapest policy or the one that their friend is selling. That's just the way it works. We have very little incentive to actually innovate. So I think there may be a place here, right, where the market is not, in fact, providing a product that would be valuable simply because of these dynamics. Well, okay, so what? Who cares? I think we all should care. We should care. The most important reason we should care is also the most obvious, right? It's that smaller governments that are risk averse, that have insurance for other kinds of losses, may under-regulate because they overestimate the potential costs associated with takings liability. That is, right, they're risk averse and they want to avoid that liability. And I think in this room, many of us may have a sense that local officials are often irrational in their assessment of takings liability, right? We talk to them and we say, look, you're not going to lose this case. You don't have to worry about this. And they say, no, we're going to capitulate. Well, why? Right? I think part of it may be that this is not an insurable loss for them, and that would be a big help. The availability of insurance would be a big help. But there are two other things I at least want to touch on. One, this is very speculative. I think there may be distributional consequences Right? That is, small local governments are risk averse in this space. Cities are not. This may at least be contributing to the reason that we see a lot more regulatory innovation in cities these days than we do in smaller towns. Part of it is expertise, part of it is development pressures, but part of it may be risk aversion. And then the last takes a little bit more time to explore, but I think it's worth doing. And this is spelled out in much more detail, this last piece, in your materials. But the effect of this exclusion is going to vary depending on how courts interpret it and how widely it is interpreted. So some courts have interpreted this exclusion enormously broadly. So there's a case out of Texas, which is fairly typical, I think. Developer trying to put in a big new mall with a Walmart, needed a rezoning. The municipality allegedly hates Walmart and says no way, that they go back and forth. It ends up in litigation. The developer ultimately sues on a variety of theories, including substantive due process, you're irrationally denying us this rezoning, equal protection, you're targeting Walmart, zoning estoppel based on representations that were made, and a regulatory takings claim. The city settled with the developer for $1.6 million, turned around and sought indemnification from its insurer, and the insurer said, no, that's all inverse condemnation. And the court said, yes, it is. Right? That is bizarre to me. Insurance policies are meant to be, under a rule of construction, construed against the insurer. But here, the equal protection, the zoning estoppel, substantive due process, no, that's all inverse condemnation. Other courts, though, have in fact taken a very narrow view and said, no, it's just about regulatory takings, right? That's what the exclusion applies to. But those jurisdictions are equally troubling for a different reason. Siri wants to hear me. Maybe Siri will have an answer for us. Because in a municipality or in a state that interprets that exclusion narrowly, it creates an opportunity for what I'm thinking of as a kind of pleadings arbitrage, where a property owner's attorney has the ability to decide whether or not to trigger the municipality's insurance. And if what the property owner wants is the municipality to simply capitulate and withdraw the offending regulation, that developer is well counseled to bring only the regulatory takings claim. Insurance won't apply, and there's tremendous leverage then to simply settle. If, though, the developer actually wants cash, wants money, plead in a way that triggers the insurance, right? And you're more likely to get a settlement. This is, I think, a kind of perverse pressure on pleading that is a result of this strange hole in municipal insurance. So in my view, the market should in fact be providing this insurance, but even if it doesn't, even if it's not going to, I think there are important opportunities for intergovernmental subsidies where more risk-neutral governments like the federal government or like states, instead of or in addition to cash subsidies, could actually pick up the takings liability and takings litigation as a way of inducing government regulation in risk-averse small local governments. So that is my proposal to you, and you survived to talk about insurance before lunch.
Just before I take questions, and we do have some time for it, I wanted just some quick housekeeping details here so you understand the mechanics of what we're going to be doing. When we finish here, lunch is going to be back in Westminster in the church, followed immediately by Bobby Percival giving the keynote address. That is from 12:30, or I guess it's from 1 to 1:30 is the keynote. We are then back here to start at 1:30. So there's no transition time built for that move. So I'd ask that people do it quickly and that our panelists also be ready to do that. Questions? Go with Alex, sure.
So great presentations, both of you. My question is for Chris, and I'm wondering how many cities, looks like you've been doing research in this area, how many cities are actually buying insurance on the private market? Because in Minnesota, we've got the League of Minnesota Cities Insurance Trust, where everybody pays in and gets paid out of that. And while you were talking, I quickly looked up where they describe their policy on what's covered and what's not covered. And under liability not covered, it says condemnation, comma, except some regulatory takings. So I don't know which regulatory takings it covers and doesn't cover, but clearly you're thinking about the issue, and address the issue, and I'm wondering how common that is nationwide.
Great. So whether or not municipalities buy private insurance or participate in risk pools actually varies quite a bit state by state. So I think that's right. Minnesota has this League of Cities. Many states do. The risk pool amounts to a kind of insurance mechanism, and those risk pools also typically include the inverse condemnation exclusion. Now, there was a proposal, in fact, it may have been out of Minnesota. One state recently in a report explicitly looked at and noticed the absence of insurance for regulatory takings claims and said, this is a problem. So we may be starting to see some movement, but over and over, every person I talked to, right, said, this is simply not insurance that is available. You cannot get insurance for your routine regulatory takings case in Minnesota. So I don't know exactly how that exclusion has been interpreted and which ones it covers. My guess is it, in fact, doesn't cover many at all.
Right there, yeah.
This is a question for Chris. I think one thought that occurred to me from hearing your talk is that if you're right, you could make a lot of money by offering this sort of insurance. You could start certain insurance, or even if you wouldn't start your own insurance company, you'd be an advisor to some other company that could do so. So it's possible this is an entrepreneur opportunity nobody has ever thought of, but it's also possible there's a deeper reason why this isn't offered. It's not a good idea. But my question is less about that than about sort of the assumption behind your argument in that you say, well, if you don't have this insurance, there's under regulation, that's a bad thing. We need to cure that somehow, either by offering this product in the market or through intergovernmental subsidies. But this implicitly assumes that absent this particular failure, if you like, the baseline level of regulation would be roughly correct, whereas obviously there's a long list of reasons that I could give you, others could give you, why municipalities, including smaller ones, will tend to over-regulate in a variety of ways. Right. So it may be that even in the world of otherwise perfect, benevolent, despot government, this would lead to under-regulation, but in the actual world that we have, maybe this incentive for under-regulation is simply an offset to what I would argue is a much longer and more extensive list of incentives for over-regulation.
Good, and so the baseline problem is a complicated one, but I guess I can rely on my second small adverse consequence in response, which is that even if you have a different view about the amount of regulation that should be out there, the distributional consequences of this rule are pretty perverse. That is, that the more risk-averse the government is, the more it will overvalue or overweight the risk of regulatory takings litigation, so that a small municipality and a large city contemplating exactly the same regulation will, in fact, view them and weigh them very differently. It's hard for me to see how one can justify that sort of as a normative perspective, whatever your baseline is about the appropriate background regulation.
Sure, I could justify it, but I'm not going to. Okay. But I think in society there are many situations where we want what entities with different levels of risk aversion to behave differently. That's actually a good thing that much economic theory strongly suggests.
So I'd like to ask a question that's kind of at the intersection of your two topics and get thoughts on it, and that is, let's assume there was offering of this takings insurance, essentially there. From Sam's point earlier, you'd also expect that there would be efforts to eliminate the moral hazard or to make this actuarially sound in terms of requiring takings impact assessments, requiring some sort of other buy down maybe or deductibles. And so a thought is, Chris, have you thought about how that would affect whatever you view as the optimal level of regulation, whether that's in line with the actuarially sound level of regulation or even what we assume would be the sort of conservative level, a margin for error? And is there a risk, you sort of point out the distributional risk of potential under-regulations in small municipalities, but is there a risk of imposition of values from one municipality to another that gets translated through the market, but not politically in that regard?
Yeah.
Well, I would say that in my experience, actually to the previous questioner's point, I've successfully explained to communities that they are far more likely to be successfully sued for allowing development in harm's way, and this is primarily in the flood context and operating against the backdrop of a very robust federal regulatory regime being the NFIP. And you've got maps with bright lines, you're in, you're out, you know, and I think that where a community chooses to permit development in harm's way, they are far more vulnerable than when they choose not to and ground that in transparently adopted standards that are consistently applied and all these other things. So I think it could really play both ways. And I would say that it's not whether or not there's insurance available for this particular legal vulnerability. It's the fact that there is insurance routinely available and universally available for so many other things that are functions of government, and this one is carved out so consistently that it's really the interplay of those two things that shines a light on this and makes local regulators view their risk around this issue differently. And if you talk to the Conference of Mayors, if you talk to NACO, the National Association of Counties, I think that their particular policy views on these things would bear that out. I would say, though, in working with insurers, short of them saying uninsurable at any cost, you can find a market. This may be a space that insurers want to play in, but they've got to be able to quantify it. They've got to be able to, have actuaries underwrite it. And as you note, there's got to be means that the industry would recognize readily of indicators of a community whose choices are less risky and indicators of a community whose choices are more risky, so that they can produce product that's, a business product.
Yeah, and there's some challenges in this space, right? Performance rating may not work very well because elections happen and you have different people or development pressures change. And so one municipality's appetite for regulation at one time can change quite dramatically, right? So there are undoubtedly problems for the development of this market, at least as a private market. It's one of the reasons that I actually think that it is more likely to be a useful source of state or federal intervention and subsidy on almost an ad hoc basis. That is, here is a regulatory regime we want to support. In this particular instance, we can do it in a variety of ways. We can subsidize it with a cash grant to get you to go and enact your new setback or response to sea level rise project, or maybe we'll just take over the takings insurance, and it might be cheaper for both of us and a valuable form of subsidy. That's my suggestion, because of those problems in pricing.
All right, that brings us to the end of our morning and early afternoon session. So we've got lunch coming. There's sort of a theme here, I think, that John has developed, that everything is sort of disasters and takings in some measure, and our next panel is expressly disasters and takings.
Confirmation.